All right, it looks like it's stabilized. Chair, we can start whenever you're ready.
Calling the meeting to order. Brian, what's our first order of business? Oh, do we have a quorum?
We do. Yeah.
We definitely do.
First order of business is memorandum 23-8. That's the minutes for the January meeting. Staff does not have any proposed revisions.
Any discussion? Going once, going twice. Is there a motion?
Moved.
Looks like the ambassador was first and Rick was second. Although it was close, Jane.
We don't record motions in seconds, so
Yeah.
Been motioned and seconded. Can we call the roll?
yes, I'm as before, I'm going to go in order that you appear on my screen. So Commissioner Hebner,
Aye.
Commissioner Simpson,
Aye.
Commissioner McAllister,
Aye.
Commissioner Carrillo,
Aye.
Commissioner King,
Aye.
Commissioner Cubas,
Aye.
Commissioner Jenkins,
Aye.
Commissioner Carrion.
Aye.
That's approved.
Next in order.
The report of the executive director. I'm going to do an operational thing here just for a moment. Hold on a second. There we go. I don't have a lot to report. I think I mentioned last time that we still have a lot of unresolved personnel issues relating to filling vacancies. And it was complicated by the fact that the State Personnel Board had decided to make changes to all of the state attorney series classifications. And then it turned out that they approved that effective February 2, but then it turned out that Cal HR was going to need a few months to gear up their operations to reflect the new system. So there's sort of a limbo state where it's difficult for us to move forward. But it's one of my top priorities because I want to get the positions filled before my retirement date. Speaking of the retirement, we have been running a financial projection to see how much slack we have for next fiscal year when I'll be retiring, in the hope that we can set a start date before my departure, so that there's overlap. So the new executive director will have a period during which they can have the reins, but I'll still be working. And it looks like we should be able to do that for at least 1 month, perhaps 2. And that's all I have for the executive director's report.
Thoughts on that, anybody?
Chair, if I might, I have one question. Brian, could you let us know the status of the solicitation of candidates for your position? Where are we on that?
I've been holding off because I wasn't sure of the start date. So now that we've got that projection in place, I expect I'm going to start distributing those solicitations next week.
We had discussed me moving it around in academia. And so I've contacted the dean of my law school and Hastings and sent them the information that I had at the time. Brian, it occurs to me, you're probably closer to the dean at UC Davis Law School than I am. So would you mind sliding an
Sure.
email over there?
Yeah, no problem at all. I'll probably be distributing it to the career services offices for all of the law schools. But yeah, the deans as well, probably a better conduit to get it to faculty members.
Yeah. Other thoughts on the executive director's report? Going once, going twice. Next in order?
Actually, I'm sorry, I was slow on the unmute. Is there going to be an effort to reach out to minority law associations and yes, okay, great. Just making sure. I figured there would be, but.
Next item is the commissioner's suggestions.
Floor is open, colleagues. Seeing none, going once, going twice. Brian, I think that concludes that item.
Legislative program status report memorandum 2023-9. There's not really anything new to report. We've placed all of the commission's legislative proposals for 23. But you know, they're all still gearing up to start moving through the legislative process. So we have that in hand. There's no new developments to report.
Questions on that, anyone? Going once, going twice? We're moving right along.
Yeah, it's actually a bit of a problem because we have, as we had at the last meeting, we've set time certain for items. And the antitrust presentation from Tom Green is scheduled for 11, so that's a ways out. But Kristen's memorandum on the Equal Rights Amendment study is set for 10. Because we have two academics who are going to address the commission on that. So we could accelerate the discussion of Fish and Game to fill this gap. I see that there is an attorney from the Department of Fish and Wildlife in the audience. If she has any objection to us taking that out of order on the agenda, could you raise your hand right now? Okay, I'm not seeing that. So we could go ahead and do that just to run out the clock a little bit on our 10 o'clock.
I see lots of nods. Let's do that.
Yes.
Steve?
All right. Good morning, everyone. So this is memorandum 2312. And it presents for the commission's approval the remaining components of a final recommendation in this study. We have, let's see. So at the last commission meeting in January, the commission approved the inclusion of a number of proposed revisions to the Fish and Game Code to be the component of the legislative portion of the recommendation. And this memorandum presents a staff draft of what would be the narrative preliminary part of the recommendation. It also presents two new proposed revisions of the Fish and Game Code and a series of technical revisions, corrections to the legislation that the commission approved for inclusion at the last meeting. So, consistent with the practice that we followed in the study consistently, I will just ask whether anyone has any concerns or questions about any of those components. And then we'll address them if anybody has any. Again, there's the narrative portion of the preliminary part of the recommendation. There are the two new proposed revisions, and then a series of technical revisions. How about anybody? I don't know if anybody's monitoring, anybody in the audience. I don't know if.
Let me pop in, Steve, and say, you know, at the last meeting, we approved the proposed legislation that was attached to the draft recommendation. This meeting, we're asking you to propose some modifications and additions to that proposed legislation. And we're asking you to approve the revision of the narrative and the narrative in toto, because it wasn't approved at the last meeting, which specifically raises the question of the discussion of the definition of fish. So I don't want to deny Commissioner Simpson an opportunity for another pun. So I want to call that out specifically. The one decision is, are you okay with the changes to the draft legislation? The other decision is, are you okay with the revision to the narrative?
Seemed a little fishy to me, but
There you go.
it's okay.
That was not a high note there. I expected more.
Chair, a question if I might.
Of course.
Steve, I understand the narrative is new. Are all the changes in the text highlighted in gray from the last version we saw?
So the answer to that would be no. The narrative part is it is new in the sense that it was not exactly the same narrative that was presented at the last meeting and passed on. But the shaded gray text is only in the proposed legislation, which is
Oh, no,
attached.
but that's what I mean. I understand the narrative we should have read fresh, but within the legislation itself are all the changes from what we've previously seen in gray.
Yes,
Thank you.
yes. And there are 2 new revisions which are in the body of the memo. So those are just presented new now in the memorandum. Okay. Questions, concerns? Looks like no one. There is one other item mentioned in the memorandum. The legislative council deputy who was assisting us in preparing the bill draft has indicated a request to put a subordination clause in the bill. This would not be part of the recommendation, but we wanted to ask if the commission had any problem with that. This is a provision in the bill which would indicate that to the extent that there is any conflict between the bill that would implement the commission's recommendation and some other bill, that the bill implementing commission's recommendation would defer to the other bill. This is typically done with this type of proposal. Any concerns? Okay. And still, Brian, nobody in the audience is anything.
I
right?
don't see any hands in the audience.
Okay, so the approval sought would be first to include the presented narrative as the preliminary part of the recommendation. And to accept the other proposed changes to the proposed legislation. I guess we can do it in 2 parts. And then I was going to ask for a motion to approve those components once assembled as being the final recommendation from the commission in this study.
Well, for efficiency's sake, if no one has any objections to any of those decisions, they could all be bundled into a single vote. Approve the draft, approve the changes and additions to the proposed legislation, approve the inclusion of a subordination clause. If
Is
someone
there-
wants to move that and nobody's objecting, that would be the easiest way to proceed.
I believe Commissioner Simpson will help us.
So moved.
Prior to the vote, though, one other question. Sorry, Steve.
Discussion.
In footnote 4,
Yes.
which is our treatment of the fish definition, have we received any opposition prior to the meeting to the text that's in footnote 4?
No, we have not.
Thank you. Sorry for interrupting.
No, I discussion is appropriate. Further discussion. I'm not sure we have a second on the motion.
Second,
The motion has been made and seconded. Any further discussion? Going once, going twice, seeing none, shall we call the roll?
All right. Commissioner Creo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
and Commissioner Simpson.
Aye.
All right. Thank you very much. We have a final recommendation.
Steve, you failed to burn out the rest of the time.
I
Yeah.
know, I'm sorry. I didn't have my material prepared for that long a period of time, but
What should we do now, Brian? Do you want to take a break? What can we do?
Well, yes, I think so. I think probably a break for 10 minutes, but I would also say, I think that discussion is going to be light at the meetings for a while. The antitrust project, we are in an educational mode where we're having these presentations and I'm organizing these experts to prepare background reports for us. And until that information comes together, we're not going to be ready really to start deliberating on policy. So there's not going to be, there'll be these presentations, but there won't be much for me to put into a memo or discuss. So that's going to be a little light. We're also going to be moving forward with returning to work on this recodification of the toxic hazardous materials statutes. Because that is a technical cleanup bill, it will be almost entirely non-substantive, and it will be one of those projects where we present a draft and you look at it and see whether you have any concerns about it. But there won't be any policy questions to discuss. So as with Fish and Game, it'll be relatively light in terms of meeting time requirements. I think the ERA study is likely to have some interesting conversations. That's why I spaced, gave an hour between the start of that topic and antitrust. But we may not use that whole hour either. So I'm just giving you advance warning that for a while, I think the meetings are, except for when we have invited guests, are going to be a little light. Because there's a lot of staff work going on. And I'm going to be drawn away over the next few months doing admin work that has to get done before my retirement date.
Brian, question about keeping the meeting schedule tight. Moving forward when we're doing the presentations, do we have to set them at a time certain, or can we just give the presenters notice, like as soon as the previous person is done, you're up to bat, be ready?
It's just a question of courtesy. These folks have day jobs and busy calendars, and it's often hard to get them to be able to fit us in at all. We're hoping in March or April to have Dean Chemerinsky attend, and his calendar is pretty packed.
I'm familiar.
Yeah, so it's easier for people to agree to participate if we can say, show up at 10, that's when we'll start.
Okay.
So-
I'm happy to go drink coffee.
Take a break until a couple of minutes before 10.
Sounds good.
All right, thank you all.
Commissioner King, are you taking a selfie? It looked like you were taking a selfie. I was just like, oh, look at you. Oh, you're on mute.
Do we want to get started?
Sounds good.
Sure. So I'll provide a brief introduction. Good morning, commissioners. So it's now 10 o'clock and we are turning to the commission's study of Equal Rights Amendment and sex equality in California law. As noted on the agenda, and as you can see in our panelists here, we are being joined by invited speakers this morning, and that's where we're going to be starting our work. I want to just note the key issue before the commission today is one that has been touched on in our prior discussions on this topic, which is how should we understand the scope of the term sex? That's the term that's in our assignment, but we haven't yet discussed what exactly that means for the commission and how broadly that should be construed. So the memo presents some discussion of some legal background, but we are also joined by guest speakers, Dean Brad Sears and Professor Carrie Franklin from the Williams Institute at UCLA Law, and they will be providing some additional context for the commission as we make this decision. The Williams Institute is a research center that's focused on sexual orientation and gender identity law and public policy. So I believe I can just turn it over to Dean Sears at this point. And I believe he's going to provide some information about sexual orientation and gender identity discrimination and provide some empirical information about that. So I believe Dean Sears needs screen sharing. I don't know, Brian, have you activated screen sharing? Let's see.
It should be available. If he tries and can't do it, then I'll.
Okay.
I think I could do it. I think I could do it. We'll give it a shot. Hopefully you're looking at a screen right now with the beginning of a PowerPoint. It's great to see everyone this morning, and thank you for having us. It is great to see David and other people on here that I know. But some of you are familiar with the Williams Institute. We're a research center at UCLA focused on doing legal as well as empirical social science research on sexual orientation and gender identity. And one of the primary areas of our research over the last 23 years has been looking at discrimination of all sorts, but including in the workplaces, which is where I'm going to focus today, against LGBT people. I'm going to present a little bit of that research, which I think helps illustrate kind of on the ground the ways that discrimination against LGBT people is sex discrimination. And then our faculty chair, Professor Franklin, is going to discuss kind of some of the legal, the cases and the background where courts have also determined the discrimination against LGBT people is sex discrimination. I'm going to focus today on findings from just one survey because it's our most recent survey on discrimination against LGBT people. We conducted it in the summer of 2020. So if you remember 2020, that was a pretty rough year. But in the summer of 2019, the Supreme Court decided the box stock decision, deciding that for purposes of federal civil rights law, discrimination against on the basis of sexual orientation and gender identity was sex discrimination. So this kind of set a national ruling that would apply here in California and across the country that would provide more protections for LGBT people. We decided to do a survey 1 year later to just kind of check in and see how folks were doing a year after this historical ruling, which hopefully had changed some norms in the workplace. Unfortunately, what we found, and consistent with other research, was still extremely high rates of discrimination against LGBT people. So the kind of orangish bars here on the left measure discrimination, which we defined as being fired or not being hired because of your sexual orientation and gender identity. The blue bars look at different types of harassment. And you can see about 30% of people reported, this is in the past 5 years, that they had been discriminated against on one of those bases, and a higher percentage had reported that they're harassed in the workplace, including and we'll get to this in a second, some pretty awful examples of physical and sexual harassment. We asked people to write a narrative as part of the survey about the last time they experienced harassment and discrimination. And having done this for 23 years, I was pretty shocked about what people were writing, occurring in the workplace. I think even more.
Dean Sears, may I ask a question?
Yeah.
Just so I understand the percentages.
Yeah.
Each one is a percentage of the sample you took,
Yes.
right?
Yeah.
How large was the sample?
The sample was about 900 people, and it was from across the United States. So this isn't just in California, this is nationally.
Thank you.
Dean Sears, can I also ask a question?
Yes.
Did you graph this as change over time?
So we asked questions like, did you have a lifetime experience of discrimination, harassment? Has it happened in the last 5 years? Has it happened in the last 1 year? This is the results for the last 5 years, where we kind of feel people's memories about what happened are probably stronger. These are all self-reports, so a court hasn't determined these are kind of actionable forms of discrimination or harassment. We also asked, have you experienced any of these things in the past year? And I think what's shocking about that is that's pretty recent in time, and 1 out of 10 LGBT people reported being fired or not hired based on their sexual orientation in the past year. Which would have been the 2019-2020 year. There are a lot of people who lost their jobs that year. So I'd also note, as we know, with kind of recessions and when lots of people lose their job, that is an opportunity for, first of all, for a lot of people to have lost their job, but for discrimination to play out kind of more rapidly. This next slide just looks at, again, these are all LGBTQ people, but compares trans people with cisgender LGBT people. And what you can see, and again, consistent with other surveys, is much higher rates of both discrimination and harassment against trans people. And so I think every bar on there is much higher for trans people, with about 2/3 reporting harassment in the past 5 years, and about half reporting one of those acts of discrimination. So again, these are incredibly high rates of discrimination and harassment. This discrimination harassment is often intersectional, and I think, and I think, as a lot of you know, a good way to sum that up is people discriminate and harass the people that they think they can get away with it. And so the more vulnerable you are or perceived to be in our society, the more likely you are to experience discrimination or harassment. So people of color who are LGBTQ tend to experience higher rates of discrimination and harassment. The orange bars here, again, on the same measures, represent LGBTQ people of color. The blue bars, white LGBTQ people. You can see in every indicator, except maybe sexual harassment, more people of color reporting discrimination and harassment. I mentioned that the sample was national, and also discussed that we asked people to kind of report about their most recent experience of discrimination or harassment. I pulled out just some of the reports from folks in California and gave a little bit of the kind of the demographic information that we have them. But you can already see kind of some of the overlap are the ways that discrimination based on sexual orientation and gender identity and sex are intertwined. And so the first respondent here reporting, people are making jokes about the way he talks. I think for both gay men and lesbians, that often has to deal with voice, appearance, mannerisms, dress that don't fit with traditional notions of the gender that people perceive them to be. We did ask people if they felt that their discrimination or harassment was motivated by religion. About half the people reported that they did feel it was motivated by discrimination or religion. We then asked them why and to explain. And again, having done this research for a long time, we've never really asked that question before. And it wasn't something they were just concocting in their heads. Most of what they reported was there were explicit references to religion as they were being harassed or discriminated against. And so you'll see a couple of examples there. The next two deal with kind of other examples of discrimination, again, kind of gendered terms or feminization of a gay man working in a supermarket chain in the first example, kind of again, the intertwining of sexual orientation and gender. And the last one is something I want to speak to in a moment, is someone who's, because of the harassment feels that they have to keep quiet in the workplace. Over half of these respondents said they weren't out to anyone in the workplace, including their supervisor or any coworkers. And so when we ran these kind of same percentages of just folks who were out, they actually were much higher. So one way that people protect themselves from discrimination and harassment is they're just not out to anyone. So if you just shrunk the sample to people who were out to other people, they experience higher rates of discrimination and harassment. And there were some patterns to that. LGBTQ people of color tend to be less out in the workplace, as well as people who identify as bisexual. There are also specific patterns to the discrimination and harassment that different parts of the LGBT T and Q experience. And so, for example, and I think this is backed up by other research, when a woman comes out in the workplace and identifies as bisexual, that's read as a sign of sexual availability. And the comments dealing with sex and go up, and the level of sexual harassment. So it's like kind of it really makes people more vulnerable to sexual harassment. Bisexual men had the lowest percentage of being out in the workplace and the highest percentage of a number of covering behaviors, ways to downplay their sexual orientation in the workplace this could range from hiding photos of your family, not putting them on your desk, not attending company events, not participating in company travel. Across the board, a lot of LGBTQ people, even who are out, over 2/3, engage in some sort of covering behavior in their workplace, ways to downplay their sexual orientation and gender identity to get in place in the workplace culture. And then I'll just wrap up about saying one thing about the kind of the main findings of the report that kind of emerged as people were writing their narratives, is that I think in 2023, most people, they don't have one job. So the environment at your particular workplace, if it's good, that's not all that matters to you. It's your environment and your community, your city, or your state, because you're going to have multiple jobs. And so what people are very aware of is not just whether their employer is good on LGBTQ issue, but as they think about where else they might move in their career, will it be safe for them there? And I think that's part of what drives. I think here in LA, it's hard to understand. Half the people are not out to their coworkers or to their supervisor. I think in other parts of California and the rest of the country, the calculation's not just about my current job. It's about where might I go in my career. Professor Franklin's going to talk a lot about the background law, so I'm going to go through the next couple of slides pretty quickly. But we've covered some of the ways, I think, in the examples that these things are the sexual orientation and gender identity discrimination are intertwined. And I think when you bring in race as well, and you think about the people doing harassing, they don't stop and kind of chop people up by one characteristic or the other. They tend to use more of a shotgun approach. And so when we got these stories about the actual harassment, it would be about sexual orientation and gender identity. Almost always the harassment also includes not conforming to gender stereotypes. And if it's a person of color, there'll also be racial epithets in there as well. And so it is, although I think the law has historically broken up these categories, that's not the way discrimination is experienced on the ground. And a lot of folks, these are just a couple of examples, who are experiencing LGBT discrimination are also kind of being criticized for not conforming to traditional gender norms. And there's a history of courts dividing up those characteristics, kind of sexual orientation, gender identity, versus whether something's kind of failure to comply with gender stereotypes types. And I think one of the judges in here writing that's kind of a tortured process to engage in and a false process to engage in because of the overlap. I just got a couple minutes left, so I actually just want to spend some time more on the research and let Professor Franklin cover the law, which is that all of this has an impact. We know that discrimination based on sexual orientation, gender identity, as well as race, gender, and other factors has an impact economically and on physical and mental health. There have been a number of studies, including by researchers at the Williams Institute, has tracked down specific instances of discrimination, have these impacts, as well as living in a climate that is less supportive of LGBTQ people. This next two particular charts just look at poverty. And again, I'm bringing them up because they're some of our most recent research. I think this one just came out this month. Looking at poverty among LGBTQ people in 2020 and 2021. Since 2009, we and others have issued a number of reports that LGBT people experience poverty at higher rates. So that is well established. You can see that within the LGBT community, different parts of the community are more likely to experience poverty, particularly trans people, women, and people with children are the most likely to be poor. Not necessarily on topic, but I think if you're sympathetic to the COVID relief packages that reduce poverty for a year or two, that's why you see the drop in 2021. Unfortunately, most of those relief programs have come to an end. And so we're waiting for the data to see whether those poverty rates, particularly for families with children, go back up. And again, just looking intersectionally, you see kind of in this graph kind of white LGBTQ women compared with women of color, both in terms of incomes of less than $75,000 a year and being at 200% of the poverty level are below, and much higher rates again for women of color who are this should be LBQ, and particularly those with children. So the end result of all of the discrimination and harassment that we're documenting is these disparities in health and economics. Thank you.
So I want to ask real quick if commissioners have any questions for Dean Sears before we move on to hear from Professor Franklin.
Could I ask a couple of questions? Dean Sears, thank you for that excellent and very informative presentation. I'm wondering if you, and you probably don't have it at your fingertips, and I'm not asking to interrupt the flow today for this information now, but I'm wondering if you did cross-group comparisons over the same time periods, you know, comparing the studied community here to other traditionally discriminated against groups.
Not in this study. We actually, you know, one challenge of doing research on the LGBT people is just the lack of data, the lack of big surveys that include.
Yeah, comparatively, I'm sure there's a wealth of data on workplace discrimination against people of African American origin, for example.
Yeah. What we fortunately, the COVID crisis, if there's any silver lining, was the federal government issued something called the Household Pulse Survey, which eventually under the Biden administration did include questions about sexual orientation and gender identity. So we don't have, I mean, I could pull together a comparison about rates for discrimination. I could say that these are much higher, I think, than for people of color reporting discrimination.
So that's what I was curious about. Discrimination and harassment in any form against any group is definitely bad, and this is not a race to the bottom, like who gets it the worst. But it is somewhat informative to know, like, is it better or worse for a particular group in a particular part of the country over a particular period of time. So that was my question at the beginning, whether you'd graph this over time, because I'd be interested to know whether changes in the law have had an effect on the reported rates of discrimination and harassment for particular groups. So is the law progressing in a way that's actually helping them?
So I'm glad that you asked. We don't really have that data because we don't have any consistent survey asking the same questions with the same methodology. But as I was looking over this morning, I was like, it's 2023. We should run the survey again and start building that.
Yeah, like the last slide I noticed, the difference between it was 12 months between 2020 and 2021. Like, well, what about 5 years before that?
What I can say is that in terms of the impact of a lot of the discrimination and the kind of all forms and stigma that people feel, the Household Pulse Survey does give us ability to look at that across groups. And what really emerges from that is that when people have multiple marginalized identities, they're really, it's the kind of Kimberly Crenshaw's theory of intersectionality is absolutely true. The rates during the pandemic at which they experienced poverty, the inability to pay their healthcare bills, their rent, their utilities. These were questions on the survey that had food insecurity, were much worse for people of color than white people, were worse for LGBTQ people than straight people, but the real concentration was among LGBTQ people of color. And then kind of every factor we looked at showed that. So that was really illuminating to show kind of when we group all LGBTQ people together, we're missing, I think, some really important patterns, that it's really trans people, people of color, and women who are LGBTQ that are driving a lot of those disparities.
So it sounds like the data show that the more protected characteristics a person has, that the more these factors affect them.
Yeah, definitely.
Very interesting. Thank you.
Thanks.
Any questions or follow-up from my colleagues? I don't want to hog the stage. Going once, going twice. Dean Sears, thank you. That was terrific. Really, thank you very much.
Thanks.
Brian, our next speaker.
So Professor Carrie Franklin is here, and I believe Professor Franklin is going to be providing some more context about the legal history, which is discussed to some extent in the memo, but Professor Franklin is much closer to that material. So I encourage you to ask questions about the legal background after her presentation.
Thanks so much, Kristen, and I'm really happy to be here with all of you today. I teach constitutional law at UCLA. I teach anti-discrimination law, and one of the central themes of my work is trying to understand the meaning of sex discrimination, or what it means to discriminate on the basis of sex, particularly with respect to sexual orientation and gender identity. So I'm happy to talk about that here with you today. I am not going to spend 15 minutes engaging in a laundry list description of all of the cases. I can provide you with a list of the dozens of cases. I will highlight some cases, but I want to talk historically and conceptually about how courts and lawmakers have thought about the parameters of the phrase discrimination on account of sex, or what it means to discriminate on the basis of sex, particularly with respect to sexual orientation, gender identity. And then I'm happy to answer any questions on that. So I wanted to start by framing this talk with Bostock. That's a 2020 decision where the Supreme Court holds that by definition, discrimination on the basis of sexual orientation and gender identity is sex discrimination. So that's the law of the land at this point. And let me just start with a nutshell explanation of what the court says in Bostock. So the court says, by definition, when you discriminate in the following circumstances, it's sex discrimination. You're an employer and you have an employee, Jackie, and she's dating a man, and you're perfectly happy with Jackie. You also have an employee named Jamal, and he is dating a man, and you don't like him, and you fire him, right? The Supreme Court has said sex is doing the work right here because you have a whole set of employees dating men, and you're only having a problem with the male employees that are engaging in that behavior. So by definition, that is sex discrimination. And then the court also says in this Bostock decision that if you have a set of women in your workplace and the only group of women that you're having a problem with were the ones who were labeled male at birth, once again, you definitionally have an employer who is engaging in sex discrimination. Now, the dissent in Bostock says that's outrageous. What it means to discriminate on the basis of sex has had a simple, clear meaning for 100 years, and it meant just discriminating against a group because you don't like women or because you don't like men, and only discrimination that takes that form is really sex discrimination. And this idea that gay or transgender people could be covered by sex discrimination provisions is some kind of woke agenda that has gone off the rails, and there's no basis in theory or in law for that. So there is a reason that that's a losing argument. There is a reason that the Supreme Court has rejected that framing, and that it's incorrect historically and it's incorrect legally. So what it means to discriminate on the basis of sex has never had one simple, clear, unchanging meaning, and there's nothing in history or law that necessitates this closed off reading that the dissenters want to give to discrimination on the basis of sex. In fact, it's quite the opposite. So let me talk for a little bit about that. Let me talk for a couple of minutes about the emergence and formation of sex discrimination law in the era when it was all emerging, the 1960s, the 1970s. We're getting a lot of provisions, and I'm going to particularly focus on Title VII, which is the federal law that bars discrimination on the basis of sex in employment that was enacted in 1964. Okay, so the first point I want to make about this landmark bar on sex discrimination is that there is not a clear understanding in 1964 when it's enacted of what the parameters of that are going to be. And that is true of the 14th Amendment's bar on sex discrimination, and that is true of the Federal Equal Rights Amendment's bar on sex discrimination. It was not the case that the people who wrote these provisions had just a simple list, a straightforward list. These things are covered, these are not. That is not the history, and that has not been the understanding of the law through time. That is what the dissenters in Bostock try to propose. But let me say, I spent 2 years going back. I spent a summer in the EEOC archives. EEOC enforces Title VII, trying to learn every single thing I could about what it meant to discriminate on the basis of sex in the early decades of American sex discrimination law. And I found a couple of things. One, lawmakers and people who enforce the law found it really difficult to understand what these provisions meant at the beginning. So the EEOC commissioner, Samuel Jackson, in the middle of the 1960s says, the sex provision of Title VII is very difficult to understand and control. And he explained it's difficult to control because it actually seems to sweep very, very broadly. It seems to suggest any time you discriminate on the basis of sex, that would be illegal conduct. And I'm not sure we're ready for that. And in fact, there's an explosion in the 1960s of panic and concern that you're going to have male executives having to hire male secretaries, and they had been used to this kind of heterosexual relationship with their female secretaries, and this was going to be extremely uncomfortable. There was a lot of talk about male Playboy bunnies and what this law was going to do to the gendered relations of the workplace and gender norms and sexuality norms that everyone was used to, because this was going to scramble it if you really meant you couldn't treat people differently on the basis of sex. Now, this objection, this line of argument just is amplified in the 1970s when the Equal Rights Amendment is proposed on the national stage, right? And Congress in 1972 passes the Equal Rights Amendment, sends it out to the state. It says you can't discriminate on account of sex. And it very quickly gets 35 of the 38 states it's going to need, and it almost passes. But then a Stop ERA campaign grows up. This is led by the conservative activist Phyllis Schlafly. And one of her main arguments against the ERA, and one of the arguments that made it more difficult to pass the ERA and eventually stymied the ERA entirely, was that it was going to protect homosexuals. Right. So she was very insistent that if you stop discrimination on the basis of sex, you were going to have to face a homosexual teacher. You were going to have to face a homosexual coach, because the only reason those people were being discriminated against is because they were men dating men instead of women dating men. And she said, that's just sex discrimination. So that understanding has been with us for a very long time. The ERA doesn't pass, so we don't have to work it out in that context. But Title VII is law. So we do have to figure out, what does this law mean? What are the parameters? What does it mean when you say you can't discriminate on the basis of sex? And so courts have to start implementing that. The 60s, the 70s, the 80s, they start to implement that. And it's kind of a mixed bag, but what really mostly happens in that era, and I'm talking dozens and dozens, probably hundreds of cases here, the court enacts limitations to avoid the far-reaching nature of the text of the provision. So there are all these kinds of doctrinal tests that evolve in order not to cover certain things. I'm going to give 3 examples. Pregnancy is one of them. So the courts say, that doesn't discriminate against all women, so it can't be sex discrimination. It only discriminates against a subset of women, those who are pregnant. And so that's really pregnancy discrimination against people who choose to engage in a certain practice. The line in pregnancy discrimination doesn't discriminate against all women or all men, so it doesn't count. The same thing with sexual harassment. People start to bring sexual harassment suits, and the courts say, no, you know what, that's not sex discrimination either, because these executives are going after particular women. So it's just these subset of women that they're so sexually attracted to. They don't really have any animus against women as a group. That doesn't count. And then most relevant for our purposes, courts in the 70s and the 80s and 90s say discrimination against gay people and transgender people is not sex discrimination, because again, you're not discriminating against all men or all women. You don't have animus against women or animus against men. You just don't like this particular subset. Like you don't like the pregnant women, you don't like the gay people. That's not sex discrimination. So courts really balk. And a lot of these courts actually in the early days are quite forthright about saying, the parameters of this aren't entirely clear, but it would just be going too far to apply this law as it seems to be written. To apply the logic or the text would interfere too much with employers' prerogatives and would disrupt gender and sexuality norms too much. So we're just not going to apply it. And we're going to develop doctrines that carve out these people, these certain categories and these certain people from protection. But then things start to change because, as you know, culture evolves. And people start to question the legitimacy of pregnancy discrimination, sexual harassment, discrimination against gay and transgender people. And then courts start to take these claims more seriously. So Kristen's memo does an excellent job running through that development. I'm not going to provide you with a kind of list, but let me just highlight a couple of important cases, a couple of important steps. Probably the most important happened in 1989. The case is Price Waterhouse v. Hopkins. So Ann Hopkins is a rainmaking executive at an accounting firm. She's bringing in tons of money. She applies for partner at Price Waterhouse. There are 88 candidates for partner. She's the only woman. Everyone agrees, had the highest performance. She brought in the most money, but she is passed over for partnership. She files a sex discrimination lawsuit, and the court says, so the accounting firm says, we didn't discriminate against her because she's a woman. We discriminated against her because she's macho, because she acts like a man, because we don't like her gender performance. We don't have any animus against women. We just don't like this woman. And the court says, no, that is sex discrimination, because The firm is saying she's too macho. They advised her to take a course at charm school. They told her to walk more femininely, talk more, I'm quoting, walk more femininely, talk more femininely, dress more femininely, wear makeup, have your hair styled, and wear jewelry. Okay, so she was told all of these things. And the firm says that's what we just didn't like her gender performance. And the Supreme Court holds that is sex discrimination, because the court says you were requiring her to conform to gender stereotypes. I'm just going to read you the key quote from Price Waterhouse. The Supreme Court says, we are beyond the day when an employer could evaluate employees by assuming or insisting that they match the stereotype associated with their group, because in forbidding employers to discriminate against individuals on the basis of their sex, Congress intended to strike at the entire spectrum of disparate treatment of men and women resulting from sex stereotypes. So the court rejects this older, it has to be animus against all men or animus against all women, and embraces this theory of sex discrimination that says if you discriminate against someone because they don't conform to gender norms or gender stereotypes, that is sex discrimination. So we then enter a rather painful period in the 90s and early 2000s, painful for a number of reasons, but one, from a lawyerly perspective, painful because there's unbelievably tortured logic and cases trying to explain why gay and transgender people aren't covered under Hopkins. So the Supreme Court has said, if any stereotype, any sex stereotype, if you're discriminated against because you don't meet that stereotype, you have faced sex discrimination. So if you don't dress appropriately, if your hair isn't the right way, if you don't talk the right way, but the court carved out if you don't date this person of the right sex from this general rule, and used unbelievably unconvincing and tortured logic to explain why every other stereotype, if you dissent from it and you face discrimination, you're covered. But if you depart from that one stereotype, it doesn't count under Price Waterhouse. We had 15 years of increasingly pressured and illogical opinions stating that. That began to change about 20 years ago. Let me just highlight a couple of cases. So in 2008, there was a case called Schroer v. Billington. This was a case at the Library of Congress. The Library of Congress, it was a terrorism and intelligence archive. They hired a person they believed to be a man named Schroer to work in the library. But when that person showed up to work, she presented as Diane Schroer, and she said, I'm actually a woman. And the Library of Congress fired her and said, we don't want you working here. She brought a sex discrimination lawsuit, and she won in federal court. And the court said in Schroer, this is just clearly discrimination on the basis of sex. Discrimination against transgender people is sex discrimination. And the court says you could look at it all sorts of kinds of ways. You could look at it like a simple logical way. You liked her when she was a man, you didn't like her then when she's a woman. Or you could look at it through a stereotyping Price Waterhouse lens. You could say she's not living up to your perceptions of how she should be performing her gender. There are all sorts of theories, but the basic underlying principles, it's clearly discrimination on the basis of sex. So there are dozens of cases that then hold that with respect to sexual orientation and gender identity. If you're interested, the EEOC website actually has an excellent list of the dozens of cases in the last 20 years that have articulated this understanding. I'll just highlight that the EEOC itself in 2012 and 2015 issued rulings holding that it believed that sexual orientation and gender identity discrimination are sex discrimination, both definitionally and on this stereotyping theory. And that, in a nutshell, is how we got to Bostock. By the time we get to Bostock, it is well established in dozens and dozens of cases and readings by judges in the EEOC itself. So I'll just conclude by saying it is a myth that this idea that sexual orientation and gender identity would be covered under sex discrimination is some kind of new innovation not supported by the history and the doctrine, and that there was always this clear understanding of what this meant, and that it only meant having animus against women because they are women or men because they are men. That was an invented formulation to try to limit the law. And the last 50 years, especially the last 20 years, have kind of been the deconstruction of those limitations that courts put on Title VII and other sex discrimination provisions to try to make sure they didn't reach too far, and the realization that that's not the role of courts to stop the law from going where the text and the history and justice itself would suggest that the law should go. So I'm very pleased that you are engaging in this important project. I'm happy to take any questions if people have them.
Ambassador.
Professor Franklin, thank you very much for the comprehensive presentation. I have two questions. First, in your professional opinion, is Justice Gorsuch a woke activist?
No.
Okay. Second opinion, second question. Religious privilege has been used historically to justify the enslavement of people of African descent. It has been used to justify the torture of the mentally ill, and it's been used to prevent women from having the vote. I would expect that religious privilege will again rear itself in the context of the current project that the commission is looking at, despite the long history of religious privilege being overcome because of the nature of the actual issue being discussed. Do you have any insights for us about the interaction of religious privilege with including LGBTQ people in anti-discrimination legislation?
Yeah, that's a fantastic question. It is obviously very much on people's minds. I guess I want to say two things. One, historically, the free exercise clause, if we're talking about the First Amendment here, free exercise protections allow people exceptions from laws of general applicability historically, meaning I have a religious belief, I don't want to follow the general law, whatever it is. And historically, courts have said to generally minority religions who are being whose practices aren't being taken into account in the laws of general applicability, yes, you can get an exception. You don't have to abide by the general rule because it is infringing your religious belief. We have seen the emergence of a very different understanding recently of free exercise, which would be free exercise used as a weapon to enable you to discriminate against other people, and enact third-party harms, which was not the historical understanding of what a free exercise exception would be. And the other thing I wanted to say is, we've already been through this movie before. We went through this, and when civil rights protections began to be enacted in the 1960s, one of the central claims by white supremacists was, we have religious views against serving Black people. We don't want to serve Black people in our restaurant. We don't want to serve interracial couples in our restaurants. Our religion prevents us from doing that. And the courts consistently and definitively said, no, you do not get an exception from a generally applicable anti-discrimination law for a religious belief like that. There's a case called, the case is called Piggy Park. It was about a barbecue joint where the owner made this very claim. We're now seeing the exact same claims that I thought we had dismissed 60, 70 years ago when we went through trying to protect racial minorities with these kinds of laws. They're rearing their head again. We have a tradition of courts saying, absolutely not. It would completely subvert anti-discrimination law and the entire project if you just allowed people to say, my religion doesn't allow me to treat people equally. We are facing that again. You will hear those kinds of claims. I think they are not historically supported. I think that free exercise was not intended to enable people to go out and hurt others, but to protect people who might be hurt themselves by laws of general applicability. Thank you for that question. I think it's an important one.
Thank you, Professor.
Commissioner King.
Thank you for your presentation. I completely agree with you that with your thoughts about how this situation is much more complex and there are nuances involving orientation, other things that lower courts have been pushing forward. But I want to ask this Supreme Court, with its conservative majority, I love the ending of your presentation saying that the trend is going this way, the courts are going this way, and this is the proper way. But it may not have any bearing on our project because we're going to do what we're going to do. But the fact that this conservative court may start issuing decisions and have started issuing decisions that are diametrically the opposite of what you're telling us the trends are. And case in point is at the end of discussion there, you're discussing about how religion, in response to Commissioner Huber's question, you said that there were cases where people couldn't impose religion to do what they wanted to do. But I believe the trend of this Supreme Court very recently, including those cases about whether or not bakers had to serve certain couples, it's really the opposite. So I'm just wondering, how does that reality fit into this very hopeful, positive trend that it's not the world, it's the world that many of us want, but it's not the world that we're seeing emerge.
Yeah, I will clarify by saying the trend that I was talking about, which was all pushing in the right direction, was to do with LGBT discrimination as sex discrimination. And there I think you have a huge body of law, and the way of the trend is clearly going in one direction. Although there are some dissenters emerging. President Trump appointed record numbers of judges to lower federal courts, and he chose those judges for ideological reasons. So some of them are not on the train. So I don't want to say that there are no dissenting voices when it comes to LGBT rights, but the trends are all in one direction. And Bostock is the Supreme Court's last word on that sex discrimination question. However, you are absolutely right. And this was why I tried to say historically, for decades, the First Amendment has been understood in a particular way. I think we are going through a period of quite rapid and radical rethinking of the First Amendment. There's a case that's going to come out this summer about a website designer who does not want to design wedding websites for same-sex couples. The oral argument made it seem like the court was fairly sympathetic to that claim. Follows from the Baker claim that you're talking about. I do think it's a much more mixed bag, and I do think this court is quite sympathetic to majoritarian Christian religious claims that they too should get religious exemptions, potentially even when those exemptions allow them to discriminate against or harm other people. So I think you're absolutely right that the trend in the First Amendment with respect to religious exemptions is not in the direction that I am articulating in the area of LGBT rights law. And I think you're both right to point out that in some instances, those laws are going to kind of ram up against each other, and we're going to have to work out how we administer these civil rights laws given claims on all sides.
Other questions from my colleagues? Going once. Victor, again.
I just have a very short question, and
Sure.
There may not be enough room or time to discuss it thoroughly. But one of the things we're grappling with, and we discussed this at the last meeting, is what do we call this project? And I'd like your recommendation. I don't want to put you on the spot, and if it's too complex a matter, well, please demur and don't give us a recommendation. But obviously, we're saying this project is to look at inequities in sex and gender. That's like sort of as narrow as you can put it. But obviously, to me, you have to go sex, gender, and sexual orientation. But then do we just keep going? And because I do feel it's very important to show that we're looking at many angles and facets, but at some point it becomes unwieldy to say that we're looking at sex, gender, sexual orientation, gender expression, gender identity, sexual expression, sexual identification, and I'm not trying to caricature that by putting it that way. Please don't take it that way. But how do we fit this balance of demonstrating we are serious about this project and we want to be broad in this project? And I think naming the project is important for that. On the other hand, not having 8, 9 words be the project. Do you have organization as to the name? And in my mind, at a very minimum, it has to be sex, gender, and sexual orientation.
Yeah, I haven't thought this through. I know, when I lecture on these subjects, and sometimes the acronym gets to be about that long, and it's hard to do. So I understand the dilemma. I would probably actually want Brad to weigh in on this as well, because I think he thinks about these questions more consistently than I do.
Well, could I ask both of you then, and in referring to something we were talking about earlier this morning, you guys might not have been on, we ran into an analogous problem with the definition of fish, which it turns out is not limited to fish. And it occurs to me that we can take a piece of that and apply it here and use the term sex to broadly define anything related to a person's sexual characteristics, whether their gender, their lack of gender, their presenting gender, the gender that they want to be, any sexual orientation or practice that a person does or does not want to engage in. So, sex defined broadly as we have come to define fish broadly. It means anything having to do with a person's sexual identity, their biology, and the sexual practices that they wish to engage in, including the opposite, including a person who is asexual and has no presenting gender. The term sex, if we read it broadly, you can apply it to all of that.
As the two professors consider their response, I would suggest Justice Gorsuch has done the work for us. I think there's a danger in taking the definition of sex and starting to slice and dice it when the Supreme Court has said sex means sex, and it has described what it means. I never like trying to separate anyone from the herd, because that's usually intended to cull the herd. So I think it's clear what sex is. And I don't think we need a long title for our project, given the referral we received. I do think clarity in a description makes sense. But I am not confused by the project that's been referred to us, or what we should call it, given the nature of the referral. So, Professor, sorry to interrupt you.
No,
Yeah, I guess.
Brad, go ahead.
Yeah. I guess I'll jump in there, and Ambassador, I think that's a good approach. It is one that's kind of consistent with Bostick. It's also consistent with what a number of state legislatures have done, which instead of passing different laws to protect discrimination on the basis of sexual orientation and gender identity, have either legislatively defined the term sex to include gender identity, gender expression, and be specific about things like this does include bisexuals and asexuals, like that's just part of a definition of the word sex. Either legislatively or courts have come in, or in some cases commissions, and have interpreted those statutes in those ways. So I think that is one model. I think in that you do want to capture sex, gender identity, and expression. I think that pretty much captures all the different specific identities that you would be concerned about. And it's
so we
consistent.
do standard, statutory drafting practice. We have an umbrella term, sex, and then we define it more particularly to include all the things that we want, and then have a catch-all at the end.
Yeah, I just want to say I like that because I have seen some courts unsympathetic to LGBT people use the fact that a statute might say sex, sexual orientation, and gender identity to argue that that proves those aren't the same things. So I think people who come at this can turn that, or the attempt to be inclusive can be turned around in certain ways by people who that's something to think about in your title. I certainly think, I think it's possible to just keep it simple and clean on the top line and then make it clear that it includes all of these things. That would probably be my preference, just having seen the way sometimes bifurcating it out causes the other, people are less sympathetic to want to say, look, it's just, here's my proof that those are separate categories.
And I think we'd be happy to pull together some examples. I actually think in implementing the Bostock decision, a lot of federal agencies have done exactly that. They've defined sex and come up with some really good inclusive definitions. I want to say one thing about religion, because I think that's just kind of intertwined with this kind of discussion about sexual orientation and gender identity discrimination, is that and just to put it in context, that like members of every major religion in the United States by clear majority support non-discrimination against LGBT people. If you look at the latest polling, it is every religion. It's only when you get to like an issue like marriage, where you have a couple of religions left, where the majority of members are not supportive of marriage equality. I think right now that's LDS, although that support is growing rapidly. Where it's not going rapidly and kind of stuck is white evangelicals. That's literally the group left where majority members don't support marriage equality. So many religious people of every religion are supportive of LGBT rights. Many LGBT people are also religious. So about 2/3 of adults in the United States are considered either moderately or highly religious by their religious beliefs or how frequently they attend religious services. About half of LGBT people meet those same definitions of being moderately or highly religious. And finally, as I said, people wrote out their stories about discrimination. When they're writing about religion, they're most often writing about specific religious beliefs specific to certain types of Christianity dealing with gender. So what they're writing is, God created Adam and Eve, not Adam and Steve. What they're writing is God created men and women. You shouldn't be transgender. So they're writing about religious beliefs, about sex and gender again. So it is, I think, just absolutely parallel to the same arguments based on race.
Further questions or comments on this topic?
Thank you both for your great presentations. It's been incredibly helpful to hear, and the summaries and just the thoughtful analysis that both of you have brought to the table. I know that, one of the things that, as an out queer Latina, out and proud, it's one of the things that I always talk about, the need for representation, how representation matters, and having folks who are lawmakers, be of the communities that they're writing for, of the communities. Have you seen in your studies there changed on the increase of rights based on the increase of representation in lawmakers of those communities? Is there a direct correlation?
Yeah, we haven't done that research, but we know the folks that have done that research and they've come to present at the Institute, and there's definitely a correlation between having members of elected bodies who identify as LGBTQ and how those issues are discussed by those bodies and the laws and policies that get passed. And kind of one of the not the dominant story of this last election, of which there were many, was that there was kind of a tidal wave of LGBTQ elected officials elected in the last election. So that representation is growing and makes a difference in states that are already supportive and in places where which are not so supportive.
Brian, are we out of time?
Well, we're getting close. I don't think Mr. Green needs to start exactly at 11, and Kristen has a decision to queue up for you all to make.
Well, I also, just from staff's perspective, I want to extend a big thank you to Dean Sears and Professor Franklin and the Williams Institute staff generally for helping point me in the right directions with getting started on this work. As they've indicated, this is a very big area, lots and lots of cases. And so I greatly appreciate the direction and the resources that were provided. So
Thank
But
you.
and yeah, thank you both for being here today. That was very helpful, and I think provides a really helpful background and context as we move forward with this. I'm happy to take the decision from the main memo now, but I realize we are pretty short on time, and we could potentially push that over until later if commissioners want to have a longer discussion. But effectively, the main question for the commission presented in the memo is whether or not we are understanding sex broadly to include the issues discussed relating to sexual orientation, gender identity. Also, the memo highlights harassment, the stereotypes issue that Professor Franklin discussed, pregnancy. So all that. And then as sort of a secondary matter, the issue that Commissioner King raised, which is how if the commissioners want to provide any direction as to how we should discuss this or present using the language to make clear what the scope of this project is. So,
Kristen, are you looking for a motion or just the sense of the commission?
well, I think, yeah, having a motion would be helpful on this question, just so we have clear direction about where the commission wants to go.
On the first question, scope
Yeah.
of the study. The issue about terminology and what we call it is something we could continue to sort of mull over, but the memos, the decision called for in the memo is a decision on whether to define the scope of this study in sort of maximalist terms as anything related to sex.
Is there a motion on that?
So moved.
Rick seconds it. Any discussion on the motion? Going once, going twice. Can we call the roll?
I will. Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Kubas,
Yes, aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Simpson.
Aye.
All right, that was unanimous and that passes. Thank you, commissioners.
Kristen, before we move on, I'd like to say that I understand Commissioner King's query and I validate his concerns. My issue is not really over the description, it's over the title.
Right.
But I am aligned with Commissioner King on the basis of his query.
So I think one of the things that might be helpful is we could drop a footnote at least to make clear, you know, how broadly we're understanding the term sex in this study initially. And, you know, we'll have to keep that in mind going forward as we start crafting language too for how to capture that. For now, absent any other specific direction from the commission, we will sort of retain the sex equality provision terminology that we've been using, which was derived from our study assignment. But if we want to change that, like I said, I'm open to that, and the commissioners can make a suggestion as to how we might adjust that. So, but that covers the main memo. The only other thing that I want to note is there was a supplement released yesterday that identifies organizations that we have been reaching out to about this topic. One of the areas that we do plan to do some more work in is identifying academic, like clinics at law schools actually, or groups that both are associated with an academic institution, but also do practice, because we'd like to find some organizations that are going to be able to help us with looking at the specific areas of California law and where there might be items that we need to focus on. So if there are any additional suggestions of organizations we should reach out to, please let us know. You can either suggest those now or just send those to me separately. But that, I believe, covers everything that we need to address. So thank you again to Dean Sears and Professor Franklin and the Williams Institute. And thank you, commissioners.
Thank you, professors. Thank you, Kristen, Brian.
Well, it's 11:02, so I feel like a scheduling genius now.
Well done.